Hello, everyone. My name is Dave Aarons. I'm the CEO of Access Legal. Are you guys hearing an echo? It's okay? You guys hear okay? Great. So I'm the CEO of Access Legal. Today I'm going to be sharing why we believe that the future of law is accessible, and also how you can position your firms to thrive financially in a modern and AI-powered era. Now, when I was 7 years old, the father of our family left our home for good. And as the story goes, he ended up having a consultation with the family lawyer my mother had known, so she couldn't work with him due to a conflict of interest. She could have pursued him for support, but as she later shared with me, my mother, she didn't know who to turn to. And as a single mother with 2 children, she also didn't believe that she could afford a lawyer. So instead, she took on international students to help her make ends meet. She started her own therapy practice and would work all day and then come home to make dinner for our entire family, as well as sometimes 2, 4, even at one point we had 6 international students. So she'd make dinner for all of them, and then clean up dinner, and then start making lunches for all of us and for them. Not surprisingly, given the stress, the grief from the separation, she developed fibromyalgia. Is anybody here familiar with fibromyalgia? Yeah. It's a very debilitating condition that causes an extreme amount of pain and fatigue. In fact, she shared later on with us, my brother and I, that the pain at times was so extreme that she didn't really think that she could be around anymore. So I experienced at that time how a lack of access to legal representation can have a serious effect on single parents as well as their children. Fast forward 15 years, and I'm recruited to a company called Prepaid Legal Services, which is now called Legal Shield. And we were one of the first teams that were generating leads off the internet to enroll clients that were seeking family law services, child custody, divorce, child support related issues, to try to get them affordable legal help. And then we would connect them with the provider law firms that Legal Shield offered, and through that plan they would receive a free consultation and a 25% discount. Now, the standard retainers for those provider law firms and the referral attorneys was typically $5,000 to $10,000, which is a traditional model of representation. And then they would apply that 25% discount. And so now the retainers they were typically getting quoted were somewhere between $4,000 and $8,000. And so, not surprisingly, the vast majority of clients that we were enrolling for these services were calling back and canceling their service immediately. And that's because they were not getting the affordable legal representation they'd sign up for, that they thought they were going to receive from this company. And we're now in a position where they were faced to have to go it alone and represent themselves. I remember thinking to myself, this is wrong. Signing up these clients day in, day out for this affordable service, but then they're not getting the help that they're looking for. Something needs to be done about this. There needs to be a way to help these people. And that began a now 20-year journey, which basically has been my entire adult life and many of the years of the team members that work alongside of us at Access Legal. And the primary question that we've been all asking from those early days is, how can we create a service model that can provide accessible legal representation to all of these families that are in need, but also do it in a way that's highly profitable and financially sustainable for attorneys? Because ultimately, that's the only way that we're going to solve a problem as large as this is it has to be also viable for all of you financially. It has to translate into real dollars and real income for all of you for it to be sustainable. And so I'm going to be sharing with you our findings over these last 20 years, which has been a culmination of efforts alongside over 4,000 law firms over the last 20 years of testing how to go about implementing these service models and doing so effectively. Now, before I do that, though, I want to ask a very important question that connects more to what your purpose is. This is our purpose. This is why we're here on this stage, is to bring you this information and these findings with all of the attorneys we work with over all these years. But I also want to ask you a question too, because it's important to reconnect to, well, why are you here as an attorney? What's most important to you? And we've been on a launch tour. Let's see if I can get this thing to work. There we go. So we've been on a launch tour for the last 3 weeks or so. We started off in Orlando, then Atlanta, Charlotte, Raleigh, Baltimore, Philadelphia, hosting meetups and workshops with all of the Access attorneys that we work with across the entire East Coast. And during that tour, we all asked them a very similar question, which is, why did you become an attorney? And so I'm going to share a little video about some of their responses.
That's a great question. I became an attorney because I felt really drawn to helping people, and I am justice-driven and really compelled to try to make sure that individuals in the system are treated with the integrity and fairness that they all deserve.
It's fighting the good fight. It's trying to make a difference in a person's life. And that's what I truly enjoy, why I became an attorney, is to make a difference.
I became an attorney because I wanted to help other people have a voice and to speak up for them when they needed it the most.
I wanted to be on the side of the underdog, and I wanted to support people's legal rights and when they thought that they had no other opportunity or no other choice.
I've actually always wanted to be an attorney since I was in 7th grade. I don't even know what else I could ever imagine doing. So.
Why did I become an attorney? Well, I have 2 older brothers that are attorneys, and I was so thankful to my oldest brother, Mike, that he didn't become a ditch digger, because it would have been monks ditch diggers. But the fact of the matter was, we all had a passion to help people. It was instilled in us by our parents. I mean, one of the obvious ones you're looking for, well, hell, I'm making a hell of a damn lot of money, you know, but I mean, I'm not sure that's where we're going.
And I didn't know what else to do. I mean, I don't know, that's not a great answer. It's probably not what you want. It's the truth.
Okay, so that was their answer. And I would like to take a minute to ask you the same question, which is, and so maybe you can grab something to write with, open up your phone if you don't have a pen and paper handy, and do this exercise with me right now. Just grab a pen or pull out your phone or something like that. And go ahead and write down this prompt at the top, which is, I became an attorney because. I became an attorney because. And we're just going to take 1 minute right now, and I want you to think back to when you first decided to become an attorney. What was it that you were looking to achieve? What impact did you want to make as an attorney? So let's just take a minute now and draft that. Continue writing if you're still in mid flow here. If not, I just want you to hold on to that answer for just a moment, because I'm going to circle back to it in a few minutes here. Because I would imagine for many of you that it might be pretty challenging to be able to live this purpose every single day given the current context of our legal environment. And I want to give you an experiential example of why that might be the case. So I'm going to ask if you can play with me here. I can have the entire room to go ahead and stand up. Now, skip ahead. Now, in the 1970s, this is a graph of access to representation in 1977. 99% of those who needed legal representation had it. So basically, almost if this is the entire room, this represents all of the people that are filing civil and family law cases in the United States every single year. In 1971 or 77 through the 70s, 99% of people could get it. Only 1% of people could not get it. So I'm going to ask maybe just you 4 gentlemen here if you guys could sit down. If you could sit down as well, sir. It's roughly 1%, right? But everybody else was getting representation. Today, that number is only 22%. That means only 22% that are needing representation in the civil and family courts are able to receive representation from an attorney. So I'm going to ask maybe just this row going back to you, ma'am. Is that Annabelle? What's up, Annabelle? How you doing? Just from you up, sir, here to you, Annabelle, and then this group right here on the same rows. Could you please stay standing? It's about 20%. Everybody else can sit down. This is the state of our current legal system in terms of the amount of people that are getting access to representation. It's only 22%. So now, who are these people that are standing here in front of us? Well, let's look at the data, right? Those 22% of people, who are they? Well, these are the high-income earners. Y'all are making over $170,000 a year, right? You're typically have about $4,000 to $40,000 in liquid assets, liquid cash, right? So when the day comes when you need to hire an attorney right away, and an attorney says, hey, it's a $5,000 to $10,000 retainer to get started, you can strike that check right away, right? Now, also, I want to pay attention to all the attorneys in the room that are in this group here. Everybody that is in this room is also competing for this small group of clients right here. And in fact, since the 70s, there are now over 3 times as many lawyers per person in the United States than there were 50 years ago. And everybody nowadays is competing for this small group of folks right here. So it's no surprise that you might be feeling the pinch, and of course, it's a very competitive environment for such a small target group. Now, the other assumption is that everybody else that's not getting representation in this room, it's because they are poor. They're indigent. They don't have any money for an attorney. Well, is that really the case? Let's look at the data. In fact, it's only 50% of those that are currently represented. When we think about that 2/3 of folks, when we think about that 2/3 of folks that are currently represented, only 30% of the people are actually low income. These are the people that are making less than $50,000 a year and have less than $1,000 in liquid assets. And so I'm going to ask maybe you ladies there, and then to you, ma'am, and then over here to you, sir. Can you guys briefly stand up for me? And then maybe just a few more folks. I want to get about 1/3. Yep, thank you. So this is the 20% of folks that have high income, and roughly the 30% of folks that would qualify for public assistance, legal aid, pro bono clinics, right? These folks certainly don't have the resources financially to hire an attorney, and that's why we have these public assistance available. But the problem is everybody else that is currently represented right now is overwhelming these organizations that provide this service to folks like this, right? Right, so everybody else, you guys can sit down. Thank you so much. But the reality is, it's not just these 30% of folks that are currently represented. 2/3 of the people that are currently represented in this country are average working families. Average working families making $50,000 to $150,000 a year. Right? They drive a decent car, nice car. You can afford a BMW on $100,000 a year. They live in a good school district. Maybe even have a $350,000 house. You know, when I think about working families, I think about my brother, who's a teacher in Michigan, makes about $80,000 a year. I think about his wife, who's a nurse, makes about $80,000 a year. I think about my mom as a therapist. She makes about $80,000 or so a year. Who do we know? Who do you know that is in this category, making about $50,000 to $150,000 or $170,000 a year? Your brother, your sister, your friends, our parents. How about you? Right? I've heard attorneys say, you know, I couldn't even afford myself the way that it's currently being delivered. And what is the real reason for that? Well, it's because the traditional model of representation is typically about $5,000 to $10,000 retainer up front. But when we look at the average liquid assets of working families, they have about somewhere between $1,000 and $4,000 in liquid cash available to invest. And then, of course, for those of you that are family lawyers in the room, if they're going through a divorce, then of course those assets get split. So now they only have $500 to $2,000. And so this is what folks can actually afford to put down, but then we have a model that is $5,000 to $10,000 to get started. We can understand why so many folks are not able to make the decision to move forward for an attorney, not able to hire your services, and are therefore ending up having to go it alone and represent themselves. So let's talk about what we can do. We were at the Equal Justice Conference, our team was, and they surveyed a number of different clients that they had worked with to try to get a sentiment for how they felt about the legal system. And then they created this word cloud that was basically a summation of the total number of responses. The biggest words on this cloud are the most common response. And of course, right smack in the middle says unfair, injustice. And so fittingly, we have named or come up with a name for our service model that we've developed over these last 20 years, working with all of these attorneys. We call it the FAIR practice model. And as I said, this wasn't developed overnight. It's been 20 years in the making. About 4,000 firms have contributed. Over 2 million clients have been served through this model of representation. And about $1 billion in legal services has been generated for our attorneys through the platform. So what is the FAIR practice model? Well, the FAIR is an acronym. It means financially accessible, FA, innovative representation. Financially accessible means that average working families can afford it. And second of all, innovative means creative in terms of structuring the payment arrangements we create with our clients in a creative way according to the needs of each client. And then secondly, innovative has to do with technology, which obviously everybody in this room is taking very seriously by being here at this conference and with the technology that's available at your fingertips. That technology also enables us to be a lot more streamlined to deliver services in a more financially accessible way and also do that very profitably as well. So let's talk about the the FAIR practice model. Here's a traditional model of representation, $5,000 to $10,000 up front, 20 to 40 hours is basically what that represents. And why has that been the case for so many years? Well, the old adage is, if you want to get paid, better get paid up front. Has anybody heard that before? Right? I mean, it's pretty common, and this comes from the fact that a lot of the tools we're going to talk about weren't even available up until about 10 years ago. Right? So we now have these modern payment tools that enable the service models we're going to be talking about today, and I'll talk about what those are. Okay, so the very first service model is what we call full representation on automatic recurring payments. A little bit of a distinguishment between payment plans, because that's like a taboo word in legal, because it's like so many attorneys say, well, I've tried payment plans that didn't work, I got burned, right? I imagine there might be some attorneys in the room that have had that experience. But the thing is, the way in which we deliver automatic recurring payments is very, very important. The success is in the details. And so one of those elements is, number one, those payments need to be automated, which again wasn't even available until 2016 when LawPay first launched scheduled payments as a tool that attorneys could use. And scheduled payments means that when you enroll that client, collect a deposit, you then set them up on an automatic recurring payment off a debit card, credit card, or you can even do it through a bank draft on a specific day or frequency during the month. And then those payments are automatically drafted, meaning from that point forward, the client doesn't have to do anything for you to get paid. Those payments just automatically draft. Second of all, what we found is you need to have that draft frequency, meaning when are they getting paid, when are those payments being drafted, the same as their income, the same as when they're getting paid, right? And so most people are getting paid weekly or bi-weekly. And so that's the frequency that you want to set up the draft payments, because the very best time for you to get paid is when your clients are getting paid. And when we think about, again, working families, when they're getting that income coming in, that's when we draft those payments. And third of all is it needs to be the same amount every single time, meaning it's fixed. As opposed to, I worked on the case for 3 hours, I send an invoice at the end of the month, 3 hours for $900. Then the next month I worked on it for an hour, then I send my monthly invoice. Then the next month I did 6 hours of representation because I was in court, I send that invoice. The problem is, average working families cannot budget for that. They cannot make these large payments that are not expected, and so they can't afford it. And this is why, unfortunately, so many attorneys begin relationships working with clients where they might pay that initial retainer, but then they fail to make those replenishments from that point forward, and they have to withdraw from the case. Which, quite frankly, I think is the worst thing we can possibly do. Right? It's just a failure for the client, failure for us. It's not a good experience for anybody. So we want to avoid that possibility. So we want to create the same amount every single time, which is a fixed amount, weekly, bi-weekly, that the client knows, I just need to make this payment every week or every bi-weekly, and then they can have the representation from that point forward. And then fourth of all is higher frequency, lower amounts. Higher frequency means weekly or bi-weekly as opposed to monthly, because it is a lot easier for somebody getting paid weekly for them to peel off $150 from a weekly paycheck than it is for them to save $600 by the end of the month. There are other costs that come into play. And quite frankly, what actually happens is their income comes in, let's say on a Friday, you process your payment that same day, and then the bank door opens. So these things batch before spending occurs, right? And if it's not set up this way, it's very easy for clients to deprioritize your fees. Okay, so let's look at how this actually looks in practice. So instead of a $5,000 to $10,000 retainer fee, full representation, auto-rate recurring payment, our access attorneys will lower the initial access point to something that working families can afford, which is typically somewhere between $1,000 and $2,500 would be a typical starting fee in almost any case. And that usually represents about 5 hours or so, 5 to 7, depending on the amount of work that needs to be put into the case to initially draft, file, and appear. In the context of criminal or DUI, it's typically 20% up front. You know, pretty much any criminal or DUI attorney we ever work with, when they first start talking to us, their offer is more or less the same, which is pay me the full amount up front or give me half down and payments from there. Right? The problem is, it's not particularly compelling because every attorney is more or less often asking for the same exact thing. And second of all, and more importantly, in the context of criminal DUI, it relies too heavily on how much that person has available in their bank account today. And when we think back to that slide about what do people have in terms of liquid cash available at any given time, it's going to be difficult for them to come up with that for representation. Whereas in this case, so many more clients are able to retain a lawyer for private representation in the criminal DUI courts rather than having to work with the public defender. And then from there, they set up those automatic recurring payments. Typically, it's going to amount to about $500 to $1,000 a month. But again, billed on a weekly or bi-weekly basis. Weekly, that's $125 to $250 a week, $250 a week every couple weeks to $500 every couple weeks. And that just depends on your hourly rate. It accounts for about 2 to 3 hours on average per month that the client is paying you, which we found over all the years of attorneys running the math on the average amount of time they spend on any given case on any given month. It averages out to about 2 to 3 hours per month, pretty much across the board, across the country. There are exceptions, but that's pretty much the average, because sometimes you might bill 5 hours because I'm going to court this month, but the next month maybe it's 0 on this file. Maybe it's 1. Then the next month maybe 3 because I'm preparing for the next phase. But on average, it's about 2 or 3 hours. And so this has been the amount of money that our attorneys typically need for the client to keep up with the billing as the attorney is delivering full representation. Does that make sense? Okay. So what has been the outcome of this full representation on our automated recurring payments? By timing it when people get paid, by doing it in an automated fashion, by doing smaller payments, higher frequency, and having those draft payments the same so average folks can actually budget for it. The question was, well, I got to get the money up front or I won't get paid. Well, the answer, what we can share with you after all these years of working with these attorneys and doing this at scale with millions of clients, with a lot of lawyers that are doing this at $250,000 a month of business, $500,000 a month of business. They've scaled this model up, and we can show that it's been a 90+% collection rate. And this is huge information, I think, for this industry, for you as attorneys, because what that enables you to know is if I set up payment plans in this way with these folks that are average working families, and I run the payment plans exactly in this model, I can confidently lower the initial access point down to $1,000, $1,500, $2,000, which is what average working families can afford, and that you can have confidence that you will get paid. And second of all, if you can lower the initial access point down to what people can afford, then 3 to 5 times as many clients can afford to hire and pay you for your services. And as a result, when we have 3 to 5 times as many hiring your services, 3 to 5 times as many people are getting access to representation. Now, what happens, for example, if they can't afford that $500 to $1,000 a month? That would be the threshold for most of the clients to retain one of our access attorneys that do the fair practice model for full representation. It doesn't mean you cannot help them at all. It just means you may not be able to provide them the full scope of representation. And so there's another service option called limited scope, which many of you may be familiar with, which just means you're providing less help rather than no help at all. So the first option is very common. This is a discrete task where they advise the client, they draft their paperwork, and then assist them with filing, and then they represent themselves as a pro se litigant, but they have an attorney assisting them with the drafting of the case, the declaration, all the forms, making sure they don't make any procedural errors in that process, which can be really, really helpful for people to actually have a positive result. And in certain states, you can write the declaration, draft a written argument for them, and attach it to the forms, which presents that written argument in the case of family law. A second common service option is draft, file, and appear. We call this phase by phase. Another word for it is limited assistance representation, limited scope representation. And this is where the attorney is drafting the case, filing it, and then entering a notice of limited representation, and then appearing for one hearing. Typically, all of these services are done as a flat fee. The draft file, the prepare and draft and file is usually around somewhere between $500 to $1,500, depending on what it is they're going to be drafting for them. And a phase of representation is typically $2,500 or so. I will say that one of the things that we found about this is when attorneys begin with providing limited scope services, even if the person couldn't do full representation at the outset, that almost 75% of the time, when you provide a limited scope service to a client, they will hire for additional services from there. You know, I think when they understand, oh my gosh, I'm going to be doing this by myself, somehow they go to the bank of mom or dad or grandpa, the money just appears, and they want to hire you for either an additional limited scope service or full representation. So let's look at the actual, now there's one other aspect of this, which is the innovative representation. And so when it comes to flat fee services, and also doing full representation on automated recurring payments, this is enabled through a merchant processing solution that requires that enables auto pay, scheduled payments, subscription billing. All of you that are members of CLEO have access to a platform that enables you to do that. Anybody know what it's called? CLEO Pay, embedded into CLEO. Right? It has subscription or scheduled payments built right in so that when you enroll that client, at the same time, you can set them up for that automated recurring payment, weekly, bi-weekly, every 1st, every 15th, whatever the frequency is that person is getting paid. You can schedule that automatic payment, have them sign a credit card authorization form, which can be built into your fee agreement, or it can be separate. And then from that point forward, you can auto draft their credit card, debit card, or bank draft. That is a really powerful technology that, again, didn't even exist 9 years ago, right? But it's been so transformative in terms of how we can engage with clients and how they can pay us over the course of time in a reliable fashion that has enabled a shift in the way we think about retainer fees. Then when it comes to streamlined delivery services, you've got CLEO Grow for intake to CLEO Draft. That means the client can fill out the intake form themselves. All that information populates right into the documents, takes what usually might have been a long time to draft paperwork and shores that up to maybe 80% less time. We have AI tools that can record the consultation and create an initial declaration through a prompt. Does a lot of the legal research for you on the cases and precedent for the strategy for your case. Can also help, of course, with the drafting, as Jack was sharing during his keynote yesterday morning. And the outcome of this is by enabling technology to help streamline delivery legal services, what might have taken you 5 to 7 hours to draft, file, and appear for somebody, when you implement all this legal technology, for a lot of our attorneys, it's only taken them maybe an hour or two. Okay. And so, on a $1,500 to $2,500 service, hour 2, 3 to get the work done, maybe with the help of a paralegal, most of our attorneys are seeing an effective hourly rate of between $500 and $1,000 an hour for limited scope services being provided to average working families that are very, very happy and appreciative to be able to have access to an attorney to help them in this way. So now let's talk a little bit about the financial effects overall. So I want to give you an example of, this has happened many, many times. We'll just take a family law case. Average client value is about $5,000. We have had some attorneys enroll for our service, start getting clients from us. And we talked about the fair practice model. All of our access attorneys deliver the fair practice model because they believe in this as a business model. But some attorneys still come on and start quoting clients $5,000 retainers. And almost invariably, they only retain about 1 out of 20 of the clients because we generate primarily average working families. That's actually what we focus on. So they make $5,000 on that 20 clients. Our attorneys on average, instead, they do the fair practice, I guess that's a TM, fair practice model. They typically retain 1 of every 4 or 5 clients. So then we apply that 90% collection rate on a $5,000 matter, that would be $4,500 if they only ended up collecting 90% on average. So then 4 clients retained at $4,500 is $18,000. And so what you'll notice here is by lowering that access point, implementing the recurring billing, they're getting retained by 3 times as many clients, which is generating 3 to 4 times as much revenue, as well as access to representation. So let's talk about all these folks, these working class families. I want you to think about that purpose that you wrote down, why you became an attorney in the first place. And I would imagine for some of you, or many of you, maybe even most of you, on some level it was to try to help people, to make a difference, to fight for those that were unrepresented or needed that representation. How many of you had some version of, I really want to help people? Thank you. By implementing these kinds of service models, we believe we have an opportunity to start for the private sector, for private attorneys, to start delivering legal services to these working class folks. To tailor the amount of service we provide them to their specific legal needs and financial budget, which is that $1,000 to $2,000 price range, and then doing that in a way that's also profitable for you financially. And if we can do that, then we can take our current model of representation, current results of representation, and we can start to serve those 50% working families, and we can go from 22% to 72%. 3/4 of families that would be getting representation at that point. So I'm going to ask those that were in the 20% here in the front, if you guys can stand up. And then all those that were in the working class families, you guys can stand up as well. Please, if you don't mind. I think, were you working families? You were the 1% before, but I think at that point were. Okay. This is the possibility for us when we start to evolve the way we deliver legal services and tailor them more specifically to what people can actually afford. And then if we can do that effectively, and we can start helping all these working families that need representation along with those that have a higher income, then so much of the burden that's currently placed on our public system for helping the folks that are, funny you, not you specifically, but you were representing them, right? The folks that are actually indigent, are have less than $1,000 in cash, making less than $50,000, and might qualify for public assistance, are not getting inundated with all the working families, and now perhaps they can start to do even more work for you folks as well. And so that moves us towards a future in which maybe you can stand up as well, and everybody in the room could potentially stand up. This would be a possibility. It's not going to happen overnight, and there will always be some folks that we cannot help for various different circumstances. But we envision a future in which finances is not the reason. We believe that the future of law can be accessible for all of us. And in so doing, you can all thrive financially in this modern AI era and hopefully fulfill on the very purpose for why you became an attorney in the first place. Thank you.